Hello, brief introduction. My name's Anthony Hughes. I've got a master's degree in law. I have a postgraduate certificate in education and I'm a retired barrister. This series of lectures, which I estimate to be about 50, will cover revision for A-level, Btec or first year degree students. All the various A-level syllabuses will be in bite-sized chunks, with each chunk being about 20 minutes and 3 20-minute bite-sized chunks will be one lecture. Don't forget to subscribe and let me know what you like and don't like. Remember, some viewers may be under 18, so any abusive language will not be tolerated, and anyone who uses abusive language will be reported. Finally, the revision slides are for revision and to add value to your lectures and to increase your knowledge. It's not a substitute for your previous lectures, so revise them as well. Hope you enjoy them. Let me know what you think, and we're about to begin. The first objective of the lesson is to consider the nature of law. The second objective of the lesson is to recognize some of the sources of English law. The third objective is to consider the origins of the common law. And the fourth objective is you will be able to identify how case law works. We will be talking about things like the rule of precedence. The first legal theory about law we're going to look at is law as rules, or positivism. John Austin and H.L.A. Hart believe law is nothing more than rules or commands for the good governance of society issued by the sovereign power in the nation. This theory is called positivism, and the study of law itself is called jurisprudence. What do we mean by rules or commands? Well, if you are still at school, you will be subject to school rules or commands, and in one sense that's law in the school, and there are penalties for disobeying those laws, such as detention, for example. In one sense, that could be a view that the school rules are the same as laws, but they're only applicable to students at the school. The person who has power over the society you belong to is sovereign. Now that can be an individual or a group, whether democratically elected or autocrats, such as dictators like Stalin and Hitler. This is Stalin and Hitler. They're the first two photographs in black and white. And democratic leaders like Donald Trump. Whether he's democratic or not, that's a question. And our Queen, who is a figurehead for the Crown, which includes Parliament and the Queen together. For positivists, it's immaterial how the sovereign obtain the power, and it doesn't require agreement of the people being governed. And I've given the examples of Stalin and Hitler, who were sovereign in Russia and Germany. Positivists would argue that the laws they made were as valid as laws made by any democracy. One of the philosophers, Richard Dawkins, says that, quote, the law is provided the law is coherent, fair and consistent, then this is sufficient. Can you see how that may be a flaw in the positivist's argument, that it doesn't care, the theory doesn't care where the power came from, it just cares that the power is habitual over society, and that provided the law is coherent, fair, and fair doesn't mean equitable, which means it's just. Fair simply means that it's fair to that rule. It's clear that the person knows what the rule is and that they haven't complied with it. That's the element of consistency we're talking about. Let's now look at another legal theory called the natural law theory and the social contract theory that stemmed from it. Here we have a slide with Thomas Hobbes, John Locke and Jean-Jacques Rousseau. Now they're all proponents of the theory of natural law, that man was born into what you would call a state of nature, and that as a result man wanted security, because without security they weren't man, or that includes obviously men and women, were unsafe and felt threatened and had very poor lives. So let's have a look at the theory in a bit more detail now. On this slide you can see on the right hand side Hobbes, and Thomas Hobbes describing the state of nature as a savage life which is nasty, short and brutish. That was in his book called The Leviathan. The theory goes that the sovereign, the person who could provide protection, would be at the top of the pyramid, if you like, which we can see. And I put a crown on the top because normally they would at that time have been crowned as kings or queens. The person who could provide security would be the sovereign. The people who would support the sovereign with their own land would be the aristocracy and the gentry, and the poor would work for them, everyone above them, and do as they're told. And the reason they would do as they're told is because they wanted to avoid a nasty, short and brutish life if they lived in anarchy. It very much values the class position. So that's one criticism of it, is it reinforces class. The ones in power are the ones who deserve to be in power because they have all the power. Let's look at the next slide. The difference or the nuance that Jean-Jacques Rousseau added was the social contract theory, that the populace supported the sovereign provided the sovereign wasn't autocratic, and therefore if the sovereign lost the support of the people because of their poor behaviour, because it was a social contract, the populace could rise up against them and replace them. So Jean-Jacques Rousseau instituted the theory that of revolution, effectively, that the population had a right to oppose someone who was ruling them if they were autocratic. And although he accepted there was a social contract, there was a effective get out clause if the sovereign misbehaved. Can you see how the social contract theory is very different to the positivist theory? Okay, this slide is not strictly within the syllabus, but I think it's helpful and it may bring extra marks for an understanding of other legal theories. I'll only talk about them briefly, however. Utilitarianism, which was from Jeremy Bentham, it's a notion that the law is there to protect the greatest numbers, and that what matters in law is protection of the greatest happiness for the greatest numbers. So effectively this means the majority rules, and if some act is going to harm more people than it's going to help, then a utilitarian would argue that it is not right to do that act because you're causing harm to more people than you're helping. You can think of lots of examples of where that could be a problem, but it's one of the theories. The second theory is a more modern theory called liberalism, and it's mainly based within American theorists like John Rawls. And it's on the basis that, okay, the liberals accept the social contract theory, but they argue that the state should interfere with an individual's freedom as little as possible, and it is only warranted when an individual's act would harm and interfere with others' individual freedoms. So there has to be a compelling argument, the liberals say, for the state to intervene. And arguably that would mean that theories of gun ownership, for example, and theories of not many controls on contracts and working hours and protection of individuals, which is very much opposed to what the utilitarian theory of benefiting the most is. So they don't stand together, they stand as almost polar opposites. But I won't go into too much detail on that, and if you want to do further reading on it, by all means do so, but be aware that it is not a crucial element of any A-level syllabus. It's an extra, if you like. The final slide before the break, finishing up on the legal philosophy elements of the lecture. Quick summary of positivism. Law is what the sovereign power says it is, provided it's clear and understood and fair. Social contract theory and natural law theory argue that there was a state of nature. Man agreed to surrender some sovereignty for protection, but if there's an autocratic ruler, the ruled say they've got a right to overthrow the ruler and replace them.